I am going to now introduce our guests for today, who will then also say a little bit more about themselves, and that they are Charlotte O'Brien and Alice Welsh. And as we know, Charlotte is the Principal Investigator in the ESRC-funded EU Rights and Brexit Hub project. And she's working with Alice Welsh to give advice to organisations working with EU nationals throughout the UK and documenting evidence of problems and discrimination encountered. And we're delighted to have both of you with us today, Charlotte and Alice. We know that you are very important voices in this field and in this discussion about what's going to be happening next for EU citizens, what awaits EU citizens in the UK. We know that there's a tsunami of issues still coming towards us, even though a lot of people don't realise that. We had at our previous speaker, Colin Year, who set out 5 groups of EU citizens that we should be concerned about, different groups. You may have the opportunity to see his podcast, and we will be making a podcast of your presentations today to share with MPs and other stakeholders. And today we've asked you to focus in, laser in on one particular group of those 5 groups, which are those EU citizens in the UK with pre-settled status and the challenges that lie ahead. So welcome, thank you very much. And over to you, Charlotte, first. Charlotte's going to speak to us for a few minutes and then introduce Alice, and then we will open it up to questions. So welcome, Charlotte, over to you.
Thank you, Roger, and thank you for the invitation to speak today. Thank you for everyone who's come. As you've heard, I run the EU Rights and Brexit Hub, which is a legal action research project based at the University of York in the York Law School Clinic, which has just recently been renamed the Baroness Hale Legal Clinic. And we do second-tier advice and drafting support with organisations around the UK. So we are a nationwide hub, helping and supporting, but also gathering evidence for an advice-led ethnography for academic purposes, but also putting evidence together for kind of policy-based discussions as well. There's another couple of arms to the project, the political science arm led by Simon Parker and John Evermy, also at York, and the quants analysis run by Madeline Sumpshire and Marina Fernandez-Reyno at Compass in Oxford. But our focus today is on evidence from the clinic. And as Roger says, we're focusing on people with pre-settled status and the problems that are coming down the line towards us. Now, if you think that there was something of a furore around the deadline that recently passed, well, recently on the 30th of June 2021, the original deadline for the EU settlement scheme, and a number of concerns that were raised by organisations working with EU nationals, by EU nationals themselves, and by some politicians as well, about the risks that were posed to people who might miss the deadline and the difficulties people were having applying and the risks of misclassification. Well, you ain't seen nothing yet, because what's coming down, harbinger of doom, that's me. What's coming down the line is a whole bunch of risks that are even greater, with potential damage that is even greater. And what's more is it's sort of a scattergun of risks as well. So it's very difficult to focus attention on any particular one date, for instance. Now, the current proposals at the moment involve people with pre-settled status having to reapply afresh, make a completely new application in order to get settled status. And pre-settled status is set to expire automatically after 5 years of holding it, which would leave people, if they have not since upgraded, completely without a status. And this is something that the Independent Monitoring Authority have issued a PAP, a pre-action protocol letter on. They're particularly concerned about this potential automatic total loss of status. It's at the stage of was at a talk with someone from the IMA recently where the government has issued its response to the PAP and the IMA are considering what to do with it. They say it's a very detailed response. I assume it's probably got stuff to do with what their provisions are for late applications all over again. But notwithstanding that, the problems that we're looking at are quite considerable. The fact that there's no fallback status, unlike the process that we've just been through, where people didn't get settled status, not just because they weren't entitled to it, but maybe because they didn't have the evidence to show they were entitled, or maybe they had difficulty navigating the system, then they still were likely to get pre-settled status. And to the extent that there's more than 2 million awards of pre-settled status, Alice will go into the numbers in a little bit, but so far as we're aware, there's only been about 200,000 or just over 200,000 people who have managed to move from pre-settled to settled status. So there's a lot of people still to go. And there's no upgrade process. There's no straightforward streamlined process that's being planned, no different system, just exactly the same system, whole application afresh, and facing the same sorts of barriers. So the sorts of things that vulnerable cohorts in particular will have experienced, the difficulties they'll have faced in order to make the application in the first place, they're going to face just all over again, except this time it will be harder because there'll be a time lag, a greater time lag in terms of evidence relevant to periods in the past. Inaccurate decision making is going to be more damaging as a consequence. No fallback status, it's all or nothing, settled status, or end up without status, end up with a complete loss of a right to reside, regardless of any accrued periods of residence or work or contributions. All of that just gets negated. Also, there's the greater risk of missing the deadline. The risk of missing the deadline is greater this time round than last time because there can't be a high profile campaign around a single deadline. Now, a lot of people have sort of cottoned onto this and are pointing out that there's going to be this scattergun of deadlines, all individualized depending on when people were awarded pre-settled status in the first place. Now, the problem here is it's even more complicated than that, because what we have is individualized windows of application, because the point at which people become eligible is going to be different for different people, depending on how long they've been resident for and how much evidence they've got of their residence. So some people will become eligible very soon and have a 4-year window in order to apply. Some people won't become eligible or be able to apply for settled status until much later. And so there's different sizes of windows of time all occurring at different points in the timeline. The idea that there won't be a huge amount of people who fall through the gaps is frankly a sort of fanciful optimism. And at this point, I'll hand over to Dr. Alice Welsh, who's a full-time research fellow working on the project with me.
Thanks, Charlotte. Yeah, so I want to talk a little bit about this issue that we've got. One of our main concerns is this transition from pre-settled status to settled status. One issue we have is the lack of data on it. As Charlotte said, there is some data out there. It's not very clear. And the Home Office has improved this data. So there is scope to get more data in the releases, but for now, it's not good enough. There's two main gaps that I want to highlight that don't help us kind of get an idea of how well people will transition from pre-settled status to settled status. The first is data that could be very, very useful to determine how accurate decision-making has been in the EU settlement scheme. That includes the fact that in the application process itself, it allows individuals to declare how long they have been resident in the UK, and we could compare that declaratory residence with the results of settled or pre-settled status. However, that data is not currently available. Additionally, there's data on repeat applications. These are individuals who might be applying again because they've been refused or their application was invalid, or because they're upgrading to settled status. We have the numbers of successful upgrades. They stand at around 250,000, but we have no idea from the numbers how many people have made a repeat application to upgrade and haven't been able to. And that would be really useful for us to see how easily people are finding that process. And that data is just not available at the moment, which is incredibly frustrating. On top of that, we are aware that mistakes in the first application have been made. There are many people who have been residing in the UK for longer than 5 years and who have been given pre-settled status. There's an issue there of awareness. It's not always clear that individuals have been given the wrong status because the letter says that they've been awarded a limited right to reside, not that they applied for settled status and got awarded a different status. So some people will not be aware of the fact that they maybe didn't get the status they're expecting. On top of that, at the Hub, we have seen cases where people have been resident in the UK for a very long period of time. A specific example I'm thinking of, someone who was resident from 2004, was awarded pre-settled status, was not aware of this, made an application for universal credit, which is what we're currently helping them with. It's on appeal. And in that bundle of documents from the DWP on their universal credit appeal, they've included national insurance records that show work spanning back from 2005 onwards. With various bits of work history in the UK. So we're aware that there are cases out there where there are records on the system for that individual's work and residence in the UK for a long period of time, but still, for some reason, in their application, they've been given the wrong status. So that kind of is a quick run around of the main issue we have with the four key issues we have with transitioning from pre-settled status to settled status. And it's important to remember that even though the deadline has passed for the EU settlement scheme, this transition to settled status is the end game of the EU settlement scheme. It's not over. It won't be over until anyone who needs to transition has transitioned. So that's kind of the first main point that we wanted to highlight. The second point, and the other point that we're going to focus on, is access to public services for people with pre-settled status. This is a huge concern. We at the Hub, we mostly focus on access to welfare benefits, but some of these issues also concern access to healthcare, access to housing, and could even be access to rights in the private sector like work and rent. Very quickly, it's worth just reminding that broadly speaking, to access welfare benefits in the country, you have to have a right to reside. Individuals with settled status have an automatic right to reside and eligibility to access welfare benefits. Although people with pre-settled status have a right to reside, the government introduced regulations that said this right to reside does not make that individual eligible for benefits, and instead they have to show an additional right to reside through the EEA regs. This is usually through work, activity, sometimes through being a family member of a worker. There's lots of different ways. I'm not going to go into a lot of detail because it would take a long time, but usually through work. And what we're seeing at the Hub, our most common issue, is people with pre-settled status being told that they cannot access benefits, and the decision makers have misunderstood the rights of people with pre-settled status. We've seen issues with individuals being told that they can't access benefits until they've got settled status, that having pre-settled status just means that you cannot access benefits. We've also seen errors where decision makers have introduced new made up hurdles for people with pre-settled status. So for example, asking for an individual to demonstrate a right to reside now, but additionally asking them if they can demonstrate a right to reside on the 31st of December 2020, the end of the transition period. That is not required. So we've seen a lot of confusion, and that confusion is also not necessarily just with one kind of decision maker. We see it commonly at local authority level, but we have also seen cases at different government departments, at DWP, at the Department for Communities in Northern Ireland. There are lots of errors being made, particularly with people with pre-settled status. Another issue that I wanted to highlight, particularly with universal credit decisions, we've seen quite a few cases where individuals with pre-settled status have been refused their benefit application with very little evidence that the decision maker has even attempted to investigate an additional right to reside. And this includes individuals who've been in quite substantial full-time or permanent work, or individuals with a derivative right to reside, and there's been very little communication with decision makers to even grasp if that's a possibility. So we are concerned that pre-settled status is sometimes acting as a kind of trigger to refuse access to benefits. And it illustrates, as often is the case, an attitude of refusing the application first and then asking the questions after. But that obviously pushes the burden onto the applicant to know that they can challenge to the rights, to know their rights under EU law as a derivative primary carer, for example, if that's the case, or that they are entitled to benefits, and have the support if they need it to challenge it. So we are seeing that process again and again. So the main issue there is just seeing decision makers seeing pre-settled status and thinking, well, I don't think they have a right to access benefits and just refusing it. So now I'm going to pass on Charlotte, who will talk a little bit about some of the challenges to those regulations.
Yeah, so as Alice mentioned, there's quite a lot of frictional administrative injustice going on. This process, this huge overwhelming process of transition from one set of rules to another set of rules, but not one set of rules. It's the fact that there's multiple different immigration regimes, each with different rights attendant upon them, with very different rights depending on different points in the timeline, is unsurprisingly creating this administrative confusion. But there's also a kind of a messy legal picture going on in terms of rights. So the regulations that Alice mentioned, excluding pre-settled status as a valid right to reside for the purposes of claiming benefits, has been challenged in the Fritilla saga that has been going on, and with two parallel cases, one that's been through the Court of Appeal, where the Court of Appeal somewhat dramatically quashed the regulations, finding them to be discriminatory against EU nationals, on the grounds that these EU nationals do have a right to reside, and it's a domestically awarded right to reside, but that's exactly what UK nationals have, a domestically awarded right to reside. As soon as you start distinguishing between the two, it kind of starts to smell a lot like nationality discrimination. The Court of Appeal agreed. However, they stayed the effects of that. The Supreme Court also extended the stay until they had handed down their judgment. And in some ways, it'd be easier to have this talk tomorrow because they're going to hand down their judgment tomorrow, but they haven't had a hearing. So at this point, it's all a case of speculation, but it seems to me that if they've made a decision without a hearing, what they've decided is that the Court of Justice case that's been going on in the interim, they must have decided that that is dispositive of the case. And the Court of Justice reached a different conclusion to the Court of Appeal, finding that these people with pre-settled status are not entitled to protection from discrimination, subtly different from finding it's not discrimination, just they're not entitled to protection ex ante. But with the caveat that refusals of benefits can't happen without examining fundamental rights first. Now, the problem that we have with the Supreme Court is these fundamental rights arguments had not been made at an earlier point, and they can only hear issues that have been previously argued, and they're not a fact-finding court. So it's not really their domain to start finding out whether the individual's fundamental rights are at risk. So in some ways, it sort of seems likely that what's going to happen is they're going to just overturn the Court of Appeal's judgment, but that leaves us with a number of disputes coming down the line. For instance, the scope of this fundamental rights duty, we're likely going to have to see further cases being escalated up in order to determine exactly what's necessary materially to protect someone's dignity, to protect their right to family life, to protect the rights of the child, and also what's the locus of that duty? Who needs to make that decision? Is it the Secretary of State for Work and Pensions at the point they're refusing benefits, or is it the local authority? And that's an important point because that will determine the means of redress that's available. And if it's the former, then it's possible to appeal such a decision up through the tribunal, which would be better than having to rely upon judicial review of an LA decision. Other things coming down the line are exactly what does all this mean for Tiller and CG for post-transition cases, because these cases are based on facts that arose before the end of transition when EU law was in effect. So they're all argued on the basis of, argued on the basis of Article 18 TFEU, but the court saw fit to make it instead Directive 2004/38. Instead, it's all going to be about the regulatory framework created by the withdrawal agreement. And that it's untested waters, and that's likely going to have to be peeled apart. Exactly what's the personal scope? What's the extent of the non-discrimination rights? Does the logic of Fritilla or CG really apply in the context of the withdrawal agreement? And that means that we're also probably going to see some potential tension, at best, fisticuffs at worst, between domestic UK courts jurisdictions and the Court of Justice. So that's something to look forward to. Watch this space. Thank you for listening.
Thank you very much indeed, Charlotte and Alice, and we'll open it up to questions. And listening to you, what I hear is a great deal of uncertainty, of confusion, of distress, plus, of course, very large numbers indeed of people involved, spread over a period of time, and the uncharted waters. We haven't been here before, and that seems to me to be a recipe, right up to a recipe for hundreds and hundreds of thousands potentially of people marching into MPs' constituency surgeries over the next few years, up and down the breadth of Britain. And so I think you're right to say watch the space. We will pass that message on to MPs, and we will get them not only to watch the space, but to watch the podcast of your analysis presentation, because they need to have a heads up that this is, the future is already here, and it's going to be coming into their constituency surgery very, very soon. So thank you so much for that. That's we'll make sure that people get that heads up. I know that Marit Sylvie from the EU's External Action Service has a question. Maybe others who have questions, would you please put those in the chat, and we'll try to get everybody in. We're going to run this until 1:45. So Marit, over to you.
Hi, thank you, Alice and Charlotte. And you might have seen my question in the chat already. We are at the EU delegation, we are often trying to understand how big or how many people are affected and where these people are in the UK. That will help us because we are constantly in touch with the Home Office as well, and we can raise these issues on our side. And do you have that information in terms of people who have been affected with denied benefits, for instance? How many people there are? Is it hundreds? Where are they based in the UK? Any other characteristics on them would be great. And the second thing, Roger, I think you made a good point. The other thing that we would like to understand is how well, in your understanding, the MPs are aware of this, and what can we do to increase their awareness of not only this issue, but in general about the EU, the millions of EU citizens who are here in the UK and who will have issues this year, next year, and will come to the surgeries and ask for help.
Thank you. A question for me, but first a question for you, Charlotte.
Well, I'm going to bounce it to Alice first of all to discuss the question of quantity, and then I'll just have a little chip in about why I think the consequences of CG are actually more widespread than the cohort we're talking about.
Yeah, so in terms of numbers with access to benefits, it's not something that we have to hand. It's quite hard to tell. I think we're planning another, or at least I have been planning another Freedom of Information request to DWP, because they can record who has been processed through the habitual residence test. And I think what the outcomes of that is, it's not clear how many of those are individuals with pre-settled status who are facing problems. However, so our data at the hub is based on advice to individual cases, and we have seen advisors come to us saying they are repeatedly seeing the same problem. So we are getting some warning signs that it is quite widespread. And in particular with local authorities, we have identified a couple of local authorities who we've then been in contact with, who have been applying the incorrect rules. And we've then been in contact to offer training and also to explain what rules should be applied. So it's quite a hard thing to measure, but it is something that we're looking to do a bit more, especially as we're starting to see patterns arise after the grace period has ended of which groups are most impacted.
Just on the number of MPs. Oh, sorry, Charlotte, you were going to come back. It was coming back to, the ball was coming back to you. So you first, and then I'll just quickly say something about the MPs, and then we'll go to Ruby. Sorry, Charlotte, back to you.
Yeah, no worries. Just to add that the political scientists in our project, Simon and John, have been conducting a survey with a number of local authorities, which they're about to do a follow-up, and we're working together on the questions that we're asking in that survey. And one of the things we're going to be doing is trying to scope out, well, first of all, get a sense of who has template letters that are being sent to people with pre-settled status, and then how many that have been sent. So we'll hopefully start to get a bit of a scaling up idea when we have the results of that survey. And then the second point I was going to make was just about the CG case, that while we're very much kind of immersed in the very granular stuff of individual cases, that the CG case, I argue, has potentially widespread ramifications, not just in the UK, but across the EU, because of the reconfiguration of equal treatment that the court goes through, the relatively contorted way it treats the law in order to reach the result that it wants to reach, has significant implications for the power or the meaning or the autonomous content of Article 18 TFEU. It sort of suggests that the Dano case law kind of supersedes Triani without explicitly saying so, all of which kind of undermines any claim that EU citizenship is as of itself connected to any rights to non-discrimination, which is a more abstract point, but I think it is worth noting that, as I described it in a blog at one point, the UK throwing a grenade, a goodbye grenade at the court as it left, it has, it has had a relatively explosive effect, ramifications that won't bother the UK years into the future, when pre-settled status is a thing of the distant memory. This potentially still will be affecting the rights of EU nationals in the EU.
Thank you. And Marit, on the point about MPs, I mean, there are MPs on both sides of the House who care about this issue very, very deeply and reflect about it, and who can be mobilised to do things. And we need to grow that number with every means possible. This is one way, through the all-party group, but many other ways as well. We need to do that, because I think however many there are now, Marit, I think in 3 or 5 years' time, it's going to be a much bigger number who know about this issue than it is now. Because as this issue trickles, comes down from the kind of the big political ideological battle of Brexit and it starts trickling through into their constituency surgeries, they're going to see this issue from a different perspective. And I think the problem is that, Charlotte and Alice said very well, I think a lot of the MPs will think, this is the end of Brexit. Now we've done this, we've done settled status. It's not the end, it's the beginning. And we don't know what we don't know. And we actually know a little bit more now, thanks to Charlotte and Alice's shining the light down the road for us. But there are things that Charlotte and Alice won't be able to shine the light on that we don't know yet. They're going to come out in the wash. So I think it's a small number now. We have to grow that number, and we have to grow that quite quickly, I think, in the interests of EU citizens, because they're going to need an awful lot of help. Rufy Siegler.
Yeah, thanks very much, Charlotte and Alice. That was as informative as depressing. But so I've got a few questions. I mean, well, one is rather speculative, and the others are more concrete. So I suppose the speculative question is: do you anticipate at any point a difference either in the way the government is going to approach a transition, free settled to settled, or indeed the courts, between EU citizens who have pre-settled status and third country nationals who have EU pre-settled status on the basis of, as you were, derivative rights that pertain to them? I mean, they're both covered, obviously, by the withdrawal agreements and by domestic legislation, but one group consists of EU citizens, the other doesn't. So, do you think that might have an effect at all? The second more concrete question is about that period for applying to transit between statuses. And am I right to say that that hasn't actually been properly set out by the government, by the regulation, insofar as it is possible that there will be a very short period after one becomes eligible to settled status for those who were in the country for a very short period before getting pre-settled status, where they may, if they miss that very short window, they will then be left without status at all. And I suppose to tag on to that and complicate it further, is there any precedent, in UK immigration policy of a situation where people, say on a work visa or other visas, fall out and have a very short window, and if they don't meet it, then are left without any legal status. And I know these are complicated, so it's fine also to tell me that we don't know yet.
Charlotte, please, Alice.
Yeah, so I'll tackle the second bit first, which is the possibility that there will be very short periods. Yes, there is a very significant possibility of that. As I say, it's also going to be extremely hard to raise awareness, to educate people as to the nature of their rights, because you can't just say you have to have applied by X, because that X date will be different for everyone. And you can't just say, well, just make sure you apply as soon as possible, because the problem is as soon as possible is different for everybody as well. And that's leaving aside the complexity that's created by the difference between when someone's eligible for settled status and when they can demonstrate they're eligible for settled status, so it's incredibly messy. And I mean, I'm not off the top of my head aware of there being a parallel situation to this. I mean, there've been comparisons with Windrush, but they don't exactly map on in this respect. I don't know, Monique, is there's something you'd like to say about what the 3 million have said about lessons from Windrush?
Yes, so we have just submitted a response to the inquiry to. It's a bit of a mouthful. Hang on, I'll give you the link because that's easier. Because it was the consultation on the progress update of the Windrush lessons learned response, which was here. And the sort of the main summary of that is that an awful lot of these problems were and are foreseen, just like you're foretelling them now, and that we feel we've not been engaged with. And then also there's very constructive suggestions on how to do it differently. So yeah, I'd leave it at that, but you can read the whole response.
Brilliant, thank you. And then the first bit you mentioned, Ruby, was the differences between different demographics. Yeah, I mean, here we're still sort of dealing with the tail end of the problems of round one, if you like, of EUSS, where we are seeing there being a very significant disparity between some groups of third country nationals, in their success or failure in their applications for EUSS. So there's been very recent figures released showing a disturbingly high percentage of Zambrano carers getting refused. That's even after there was a purported change in policy and approach to Zambrano carers. And so, it feels like we're still kind of working through that before we even look ahead at what the situation is going to be for transition between pre-settled and settled. It's worth noting that as time goes on, we're going to have to do a lot more of getting a lot more au fait with the terms of the withdrawal agreement and how to deploy them, how to deploy the provisions in legal argument. And it feels like there might have been some sort of resistance in some legal circles to doing that so far, because EU law feels like safer ground. But when it comes to protecting people's rights, particularly people with pre-settled status who look at losing all their rights, that feels at odds with what's in the withdrawal agreement. And that's why the IMA has stepped in with their pre-action protocol. But yeah, I feel like we need to do a lot more to operationalize the withdrawal agreement, to the extent of also making sure that people are conversant with their own rights vested in the withdrawal agreement. At the moment it occupies this weird shadow territory of esoteric legal specialism, and people need to be better informed as to their rights. Alice, did you want to add anything?
No, I think you covered it all, only that with the non-EEA nationals, I think based on the fact that we have seen higher refusal rates, it is not entirely unreasonable to expect that there will probably be more problems in the future too.
So, Monique, I think you had some questions as well. Please go ahead.
Yeah, I just wanted to ask also, I think it's also worth raising awareness of the dreadful delays in the system, because they impact on all of this as well. I mean, it impacts across the board, but also to people applying to upgrade from pre-settled to settled status. And it ties in with what Dr. Ziegler was saying about the very narrow window that some people may have, because I mean, the Home Office have indicated that they think they're going to clear the backlog by the spring. I don't think there's any evidence to support that. We think it might well be the spring of the following year, looking at the numbers, because the number of applications from these upgrades is kind of going to hold steady. The number of cases concluded is just going down by month. So if you just do a straightforward calculation and not even assume it's going to get any worse, it would take another 18 months. And specifically, one type of delay within that, which is really serious, is the delay to certificates of application, because that's your ticket to getting rights. I mean, let alone the fact that even when you have rights on paper, you're often not getting them in practice, but you don't have any rights until you get that certificate. So I imagine for someone who's only got a month to apply for settled status, sort of at the back end of this period, and it's got a very short window, unless that's sorted out by then, I think that's a problem. And I'm just going to plug another one of our reports that we've done to the IMA, which is specifically about delays. But the quick question that I had it's just a little techie question actually to Alice. You were saying about the lack of data about how accurate the decision making has been, and that people self-declare whether they're going to get, how long they've been in the country. Now, I haven't actually, because I've not gone through the process myself, and we don't do casework, I haven't actually, and I know the process just keeps changing, but is that now a question that is asked? Because I certainly know at the beginning it wasn't, was it? So I just wondered if you could tell me when that changed and whether the data's there in theory.
In
Charlotte,
theory,
just before you
yes.
answer,
Sorry.
if I may, I'm delighted that we've been joined by Stephen Timms MP. Stephen, hello, thank you very much indeed for being with us. As you can see, we've got...
Sorry, I'm so late.
No,
I've missed most of it.
We know that everyone's very, very busy. Thanks for being here. We've got, as you know, we've got Professor Charlotte O'Brien with us and Dr. Alice Welsh from the EU Rights and Brexit Hub. They've given us a presentation on the challenges that lie down the road with upgrading the 40% of applicants who have pre-settled status to settled status, and we're making a podcast of that, which we will send you, so you can see Charlotte and Alice's presentation and perhaps share it with colleagues, because it's quite concerning. And I think it will give colleagues a heads up about the kinds of issues that are going to be coming, and probably are already coming into your constituency searches, and certainly will be coming into your constituency searches tsunami potentially over the next months and years.
Let me just make the point, Roger, that on the Work and Pensions Select Committee, we've been particularly interested in questions about benefit entitlement for people that we're talking about, and we've valued the input we've had from some of those on the call on this, but we'll be continuing to follow that with a lot of interest, because I think there's some uncertainty at the moment about who exactly is entitled to what. Great.
So we were going to finish this meeting at 2:45. If you've got a bit more time, and our guests have got a bit more time, I'm happy for it to run on. There's a question from Stephen, Charlotte, but you also were going to come back to answer Monique's questions. Take a deep breath. We'll count to 5. Can you respond to Stephen and then also respond to Monique as well? And then we should have time for another round. Would that be? I think you're nodding. Yeah, over to you, Charlotte. Thanks, Stephen.
Well, I think probably actually I'll hand straight to Alice, because there was a question directly about what she was discussing, the data opacity problem.
Yeah, so the issue I have with the applications, admittedly, we don't also do casework on EU settlement applications ourselves, so I haven't seen the application in a while, and I'm aware it would change a lot. So my awareness of this question came about quite a few years ago, and I can't recall. I can try and find out what date it was introduced and if it remained. But it's definitely something that I feel needs a little bit more openness from the Home Office. If they have that data there, obviously it is declaratory, so it cannot be taken as completely accurate, but there's some data out there, at least for some applications, where individuals said, I have been in the UK for this long, and you could potentially measure that up with the conclusions of those applications to see a little idea of how accurate some of those decisions were. On your issue of delays, I would add to that as well, although not specifically about individuals with pre-settled status, there's absolutely issues with delays, and that has consequences for the EU settlement scheme side of things. But we're also concerned with consequences to access for benefits, particularly because there was an announcement, a press release back in August about temporary protections for people who made late applications and pending applications. But the guidance for decision makers at both the DWP at the local authority and the Home Office's own public funds for migrants guidance all contradict each other. They all say different things about how decision makers should be handling pending applications. Some require a certificate of application plus a right to reside. Some suggest individuals just need a certificate of application. And some introduced, the regulations actually require that individuals have a certificate of application, a right to reside, and a right to reside back in December. So they all say different things, and we're not confident that decision makers, that the decisions made on people with pending applications will be consistent and fair or accurate. So that's something that we're investigating further. We're trying to get as much evidence of what guidance is out there, and we're hoping to put something together, potentially a blog on that soon.
Great. And Charlotte, have we picked up Monique's question?
Yeah, I just wanted to add on the point of delays regarding certificates of application that we saw a case recently that involved a delay in the issuing of a certificate of application, which, as you say, has suddenly become the proxy for actually having EUSS status, that had a very significant effect on the applicant's ability to work. She got offered 3 different jobs and she couldn't take them up because her certificate of application hadn't come through. And delays in general, we see quite a lot of the problems with the EUSS, especially with the outliers. So it's all very well talking about average times, but when you're dealing with people who've been waiting for an extremely long period of time, one of our first cases involved someone who'd been waiting for 15 months, and during that period of time was deemed ineligible for benefits, and then when she got, it was settled status eventually, and I think it was a third country national, so again, dealing with that complexity, the administrative complexity, she was deemed only to have settled status from the appointed the award rather than the time when she applied, when she would have been eligible. So that was 15 months of lost benefit entitlement as a consequence, which is quite drastic and significant effect on quality of life. But yeah, there's been, so to turn to Stephen's question, sorry, can you just remind me what the question was?
Well, I was simply making the point that on the Select Committee, we are following with interest the question of the entitlement to benefit of EU citizens. And my understanding is that if you've got settled status, that's fine. If you've got pre-settled status, that's probably okay. If you've applied and not had an answer yet, then you're in trouble. And any kind of updates on what's happening there, or whether the position has got any clearer since the committee was last briefed on this, I'd welcome.
Well, it's not got clearer.
Okay.
It's got considerably messier. So you're quite right. As far as settled status is concerned, once it's been awarded, someone is entitled to equal treatment with UK nationals. So provided they meet the same conditions, then they're entitled to benefits. With pre-settled status, it's messy. So it depends on whether we're dealing with benefits that have traditionally required a right to reside, typically means tested benefits, and the government's regulations introduced just a couple of months after the settlement scheme was rolled out. The government essentially realised what it had done is had created an effectively unconditional right to reside, which would lead to entitlement to benefits, and then created these regulations to stop pre-settled status counting as a right to reside for the purpose of claiming benefits. So if you had PSS, you had to claim, you had to show you had a different right to reside, so typically be a worker or a family member of a worker in order to get benefits. Court of Appeal, this is my my little run through this huge litigation saga. Court of Appeal quashed those regulations, but stayed the effects, quashed them on the grounds of them being discriminatory because they people with PSS have a domestic right to reside, which is comparable to a UK national's domestic right to reside. So distinguishing between the two discrimination grounds of nationality, stayed. Supreme Court extended the stay pending their judgment. In the interim, we have the CG judgment from the Court of Justice, which reached a different conclusion to the Court of Appeal, found that people with PSS are just not entitled to protection from discrimination, but they are entitled to invoke fundamental rights. And so it's a question of whether their right to dignity in particular is infringed or at risk of being infringed. Now, this then means the Supreme Court has taken this into account, but they've decided they're going to hand down their judgment tomorrow without a hearing, which suggests they think that CG is dispositive of the case, which suggests that they don't need to have a hearing, which means they're unlikely to be considering questions of fundamental rights, which in some ways is not that surprising because it's an argument that wasn't made beforehand in this case, and the Supreme Court can only hear appeals on previously argued points, and they're not a fact-finding court, and so it's not their place to find out whether the Fratilla and Tenaze's fundamental rights are at risk. So chances are, I don't know, this is speculation until we have the judgment tomorrow, chances are that it's going to overturn the Court of Appeal's finding, which means the regulations hold good, which means people with pre-settled status have to show another right to reside, which has a significant impact upon vulnerable people in particular. There's going to be people with broken work histories, or people who are in and out of work or have childcare responsibilities are going to find it harder to claim benefits. Now, that still leaves open a number of questions, which is when does the fundamental rights caveat kick in? And so one of the things I was saying in the presentation is I predict that these are going to be disputes held in the future, that there will be future cases that will have to be argued from the start on the basis of fundamental rights to find out exactly what the scope is, what's materially necessary to stop someone from losing or not being able to realise their right to dignity under the Charter. And that also makes it even more messy when it comes to post-transition cases, because, well, as you know, the Charter of Fundamental Rights is not part of the body of retained EU law, but it does sort of percolate back into UK law through the back door, because it forms part of Union law in the Withdrawal Agreement. And the Withdrawal Agreement has direct effect thanks to the Withdrawal Act 2020. So the Charter will still be relevant, but in a confused way. And so yeah, I think there's going to be future arguments about this, but also about the personal scope of the Withdrawal Agreement and what counts as a protection from discrimination under the Withdrawal Agreement.
Thank you, and thank you, Roger. We've clearly got to wait for what the courts say, but that's a very helpful update. Thank you.
Stephen, just before you leave this, very quick question to you. Yes, thank you so much, Charlotte. We are recording this, so we will try to edit in some of the questions, but certainly the presentation itself, we might try and edit in some of the exchanges, if that's okay. The question that came up earlier, Stephen, is what extent do you think colleagues of yours from both sides of the House are aware of the fact that this issue has not gone away? In fact, it's going to probably grow and grow in the years to come. It's not something that's behind it, it's something that's ahead of us.
Well, it's certainly something we've talked about on the Work and Pensions Select Committee. I mean, elsewhere, I think probably at the moment other things are dominating people's attention, but I don't think if members of Parliament were asked, do you think this has completely gone away? I don't think they'd all say yes. I think there is an awareness that there is some unresolved issues here, as Charlotte has just made very clear.
Thank you. Thank you.
Thank you. Thanks for having me.
With us today, and
nice to see you, Roger.
Good to see you, Stephen. Very good to see you. Thank you to our guests from some of the embassies, Stephen, in London, and consulates and from some of the campaigning groups, including my colleagues of mine from the New Europeans and from the 3 Million, and also from the EU External Action Service. And a big thank you to our presenters of today, Charlotte and Alice. Thank you very much indeed. We will share that podcast with you before we send it round to MPs, just to check that everyone's happy with that, and keep everyone posted about further developments with the APPG. As I said, this is one important channel, I think, of communication, but given the scale of the problem that you have and challenges ahead that you've set out for us today, Charlotte and Alice, we need to mobilise all available means to get this message across. Stephen, thanks again to you. Have a very good afternoon, everybody, and yeah, let's keep our fingers crossed, but not hold our breath, as they say, so to mix my metaphors about what happens tomorrow. It sounds like we need to revisit things very soon in the light of what happens then. Thank you very much, everybody, and look forward to seeing you again soon.